Joining us now to help us further digest what all of this means, legal expert, attorney Andrew Lieb. Andrew, thank you for being with us today on this big news day.
Chris, it's a huge Supreme Court day. Justice Thomas on his birthday issuing a groundbreaking decision.
Yeah, well, look, I want to ask you about this. So on the one hand, not a huge surprise given the makeup of the court here, but on the other hand, this is going to mean a major shift in gun laws, not only in New York, but other states as well. What at its core does this decision mean today?
New York previously had a law that said the presumption was you couldn't have a gun unless you had a particularized need for safety. Now we're like the 43 states that have shall issue laws where the presumption is you get a gun except in exigent circumstances. And as we were discussing before, Chris, it's about whether we have a sensitive place. And we only have 3 listed sensitive places in the opinion, and they have to use through analogy whether it resembles an assembly, a polling place, or a courthouse to see if we could expand that list to places like bars and subways, as we alluded to in the previous package.
Wow. Okay. So the governor is also suggesting she's going to try to call the legislature back for a special session, presumably to pass something in response here. What could she do? What legislation would that be?
It's all going to be about history moving forward, and I hate to say that with the word legislation, but what they told us, what Justice Thomas told us in his opinion, that it's no longer an issue if it's promoting a important public interest like safety. It's just if the history and context goes back to 1791 when the Second Amendment was passed. So what we're going to have to do is look at what were sensitive places back then and have historians working with the legislature to show that it has solid ground in history to say that's a place we should have no guns.
And does today's ruling mean that private businesses now can put up signs saying we forbid the, bringing in concealed weapons into this establishment, or does the legislature have to pass a law before they can do that?
No, a private business can generally do that, and the reason why they can do it is the amendments on the Constitution are about the government restricting rights. For example, free speech that we all hear about. Twitter can restrict your speech. The government can't do it. The same thing goes with the Second Amendment. It's about the state or the federal government restricting gun rights. Private businesses are free to do as they want.
We just have a few seconds left, Andrew, but just in terms of the court's history with tackling gun laws, the last time they took up the issue was 2010. How significant is today's ruling in terms of history?
Well, in 2010 on the Heller decision, they talked about whether you could have a gun in your house. Now they say a gun can be held anywhere because it's the most important thing for personal safety. And they also say it no longer matters, as the courts had thought, what the government's interest in protecting safety is. Just history lessons moving forward. So to answer your questions, it's become a more robust law where people can have their gun in the United States. The presumption is you get a gun for safety. That's what we learned today.
Wow. Well, Andrew Lieb, we appreciate you being here to help us break this down and understand it today. Thank you very much.